Okay.
I think. Ready now?
Yeah, they got it. Okay, we're now going to continue with the case, and we just finished with the cross-examining from the prosecution of Tanya Morgan, so would you please call up your next witness, defense?
Your Honor, the defense would like to call Mr. Brad Stevens.
Brad Stevens, would you please approach the bench, the stand? Bailiff, would you please swear this witness in?
Raise your right hand. You solemnly swear that the testimony you give is the truth, the whole truth, nothing but the truth. Say I will.
I will.
Say your full name and spell your last.
Brad Stevens, Stevens.
Proceed.
Your Honor, may I please quote the witness?
Yes, you may.
Good morning, Mr. Stevens.
Good morning.
Excuse me, counsel. Bailiff, could you please give the mic? Thanks.
Mr. Stevens, do you go to school?
Yes.
Sorry.
And what school is that?
South High.
What were you doing on June 4th at about 8 p.m.?
I was playing Frogger at Million's Video Arcade.
Did you break the game record?
Yes.
And were you with someone that night? Mr.
Yes, I was.
And who is that person?
Miss Tanya Morgan.
Was this your first date?
Yes.
Witness, I need you to speak into the mic or speak louder, please.
All right.
What happened after you beat the previous machine record?
I ran out of quarters.
So where'd you go?
I went to the quarter machine.
And what happened when you returned to the machine?
I saw Martin Mann playing the game.
And what did you have to say, Mr. Mann?
I just asked him if I could play the game because I was there.
Then what did Mr. Mann have to say?
He told me, he said, "There's your game over there, jackass."
What was Mr. Mann's state of mind while saying these words?
He was mad.
Was Mr. Mann embarrassed in front of his date?
Yes.
What happened
Objection,
next?
Your Honor. Calls for an opinion.
Objection overruled. Continue with the question, Counselor.
You said again, was Mr. Mann embarrassed in front of his date?
Yes.
What happened next?
Well, he pushed me.
And would you have fell on the floor from a push that Mr. Mann had demonstrated here the other day?
No.
How hard did he push you?
Pretty hard.
Mr. Stevens, did you trip when you were pushed?
No.
And how did you fall to the floor?
Backwards with my hand.
Did you injure yourself?
Yes.
What part of your body did you injure?
My wrist, my right wrist.
So what happened as you were on your back on the floor?
Well, I looked up and I saw Mr. Mann walking towards me.
And what stopped Mr. Mann from further inflicting pain upon you?
The two girls.
So you were saying they were restraining you?
Yes.
Objection, Your Honor. Leading the witness to testimony.
Objection overruled. Continue.
So you were saying that Mr. Mann was being restrained by Miss Cook and Miss Warner?
Yes.
What? Did Mr. Mann say anything to you as he was being restrained?
Yes.
And what did he say?
He said that if you see me again, he's gonna mess me up, beat me up, something like that.
What was Mr. Mann's state of mind as he said those words?
He was mad.
What happened next?
I went to go. My hand was bleeding, so I went to the fountain to go rinse it off.
And where is the fountain located in comparison to the front of the store? And
By the door,
can you point it out on the map?
right there.
Your Honor, please let the record indicate that he has pointed to the fountain.
Okay, the record will show that.
And isn't the fountain next to the doorway?
Yes.
Mr. Stevens,
Yes.
which hand did you injure?
My right hand.
Mr. Stevens, are you right-handed?
Yes.
As you were going to the drinking fountain, Mr. Stevens, was your right hand hurting?
Yes.
Was it bleeding?
Yes.
Was this the hand you fell on?
Yes.
What happened as you and Miss Morgan were washing your hand?
Well, I saw Mr. Mann walking at me.
Is this what appeared to be in Mr. Mann's hand when he was coming toward you?
Yes.
Was this the next time you had seen Mr. Mann after he had threatened you?
Yes.
What was going through your mind at this point?
Objection,
scared.
Your Honor. Calls for conclusion.
Objection overruled. Continue with the question.
What was going through your mind at this point?
I was scared.
Did you fear for you and your date's safety at this point?
Yes.
With your right hand injured, could you adequately defend yourself?
Objection, Your Honor. Asks for expert testimony.
Objection sustained. Jury, please disregard that question. Counselor, continue with another question.
Can I have a 10-second recess?
Yes, you may.
with your right hand injured and bleeding, did you feel you can defend yourself?
No.
So what did you do to defend yourself in your day?
Well, when I saw him coming at me, I picked up that piece of wood.
And were you embarrassed in front of your date?
No.
And Mr. Stevens, which hand did you use to hold the wood?
My left hand.
Do you use your left hand well?
No.
At what point did you reach for the wood?
When he was about ready to jump on me,
And where was this piece of wood?
it was on the windowsill.
And what happened next?
I hit him.
Okay. Did you know you knocked Mr. Mann unconscious?
No.
Did you act on self-defense?
Yes.
And Mr. Stevens, do you have the right to self-defense?
Yes.
Why is that?
Because that's what the law says.
So what did you do after you hit Mr. Martin?
I ran. I ran out the door.
Why did you run?
Because I was scared he was going to get up and come after me.
What happened while you were running away?
I looked back and I saw Mr. Cervantes. He was chasing me.
And did you stop?
Yes.
Could you still have run away from Mr. Cervantes?
Yes.
Why didn't you run?
Because I figured he was there and nothing else was going to happen.
What did Mr. Cervantes ask you?
He asked me why I hit him.
And what did you say to him?
I told him because I had to.
And what was the reason that you said that?
Because self-defense.
Can I have a 10-second recess?
Yes, you may.
No further questions, Your Honor.
Okay, thank you. Prosecution, would you like to cross-examine this witness?
Yes, I would, Your Honor. May I approach the witness?
Yes, you may.
Your Honor, would you ask the witness to answer all questions with yes or no?
Would you please answer all questions, yes or
You're
no?
allowed,
Yes.
Counselor. Mr. Stevens, on June 4th at about 8 p.m., you and Miss Morgan were playing Frogger at Melanie's video, okay, correct?
Yes.
And-
Oh, Your Honor, can you please ask him to scoot back? He's intimidating me.
Counselor, would you please move back?
And you beat the previous record on the machine.
Yes.
And then you and Miss
I need
Morgan-
order in the court. We can't hear what the counselor and the witness. If you feel at any time that you need to have, everybody be quiet, you can go ahead and tell me.
And then you and Miss Morgan went to get some quarters, correct?
Yes.
And when you came back, you found Martin Mann and Miss Cook at the machine.
Yes.
And you told Mr. Mann that you were using the machine and that you left for a moment to get some change.
Yes.
And then you told Mr. Mann that he should go play Pac-Man, is that correct?
Yes.
Do you own the Frogger machine, Mr. Stevens?
No.
Objection, you willing to the case?
Objection overruled. Continue with the question.
But you thought that it was still your machine even though you left?
Yes.
Then Mr. Mann told you sarcastically that you should go play Donkey Kong, correct?
Yes.
Then you attempted to use the machine again, correct?
No.
You didn't try to use the machine again after he told you no?
No.
May I have a 10-second recess?
Yes, you may.
Your Honor, may we approach the bench, please?
Yes, you may. Both counselors, yes.
It says right here that Brad attempted to use the Frogger machine again. And this is his testimony.
Okay.
His question was so clear. He needs me to say.
Okay, I'd like to remind you, Mr. Brad Stevens, that you are under oath, so what you say is supposed to be the truth, and please tell the truth.
Okay, so when you saw Mr. Mann and Miss Cook at the machine, you tried to shoulder your way in, and play the game, correct?
Yes.
And then after he told you that he was playing the game, you tried to play it. You tried to shoulder your way in and play it again, correct?
Yes or no answer, Mr. Stevens.
Can you ask the question again?
After Mr. Mann told you that he was playing the game, you tried
Need
to use
order
it
in the
again.
court, please.
Yes.
So you did try to use it again after he told you that he was playing.
Objection, harassing the witness.
Objection overruled. Continue with the question and answer.
Okay, don't you think that you tried to use it once and he told you no, and then you tried to use it again? Don't you think that was provoking Mr. Mann?
No.
Cause for opinion.
Objection overruled. Continue with your question.
When you tried to use the machine again, Mr. Mann supposedly shoved you, correct?
Yes.
And then Mr. Mann came toward you, correct?
Yes.
And when he did come toward you, he was stopped by Miss Morgan and Miss Cook.
Yes.
Then Mr. Mann supposedly said something to you, correct?
Yes.
Did this incident embarrass you in front of your date?
No.
No? After this incident, you had two things you could have done. You could have left the arcade.
Objection, compound question.
Objection sustained. Jury, disregard the question. Continue with another question,
Mr.
Counselor.
Mann, after this incident, did you leave the arcade?
No.
Did you stay in the arcade?
Yes.
And then you went to wash off your hand, correct? You went to wash off your hand.
Yes.
And then you saw Mr. Mann walking quickly towards you, correct?
Yes.
Counselor, I need you to speak up because I can barely hear you.
And Connie Cook was with you, was with Mr. Mann at that. And Connie Cook was with Mr. Mann walking quickly towards you, correct?
Yes. But no.
Huh?
Yes, but no. Can I say a sentence? Your Honor, Your Honor, Your Honor.
The counselor has instructed me to have to ask you to answer all questions yes or no, so no.
Yes, Your Honor.
Do you think that if Mr. Mann was
Objection, cause for speculation.
Yes, Counselor, we need to hear the whole
do
question,
you
then
think
you
if
may
Mr. Mann was
object.
going to do something?
Counselor, I need to finish my sentence before you proceed. Go ahead and continue with your question, but if there's an objection, we need to stop and I need to make my decision, okay? Is that clear?
Yeah.
Thank you.
Do you think if Mr. Mann was going to hurt you in any way that he would take his date along with him?
Objection, Your Honor.
Calls for opinion.
Objection sustained. Jury, disregard the question. Counselor, would you please continue with a different question?
Okay. When you looked up and saw Mr. Mann coming at you, he was about 13 feet away, correct?
Objection, Your Honor. Calls for opinion.
Objection overruled.
Can we approach the bench, Your Honor?
Yes, you may.
It says it.
He's 13 feet away.
It says it.
He can't tell at that point. No, how does he? Did you receive a message? Hey, you didn't receive a fact sheet, did you? He only knows what he knows and what's on his paper.
It says it in the fact sheet right here.
That's Martin Mann's fact sheet. He does not have that.
Martin Mann was about 13 feet away, so was he.
He does not know that.
Okay, yeah, we're looking for his testimony only, so. Okay. The question is that if Martin Mann was 13 feet away, right, Counselor?
Yeah.
Okay, I'm going to sustain that question because we're looking for Brad Stevens' testimony only. And jury, would you please disregard that question? Continue with another question.
Mr. Stevens, have you heard of the minority rule?
Objection, Your Honor.
It's irrelevant.
No, it isn't.
Overruled. Continue with your question,
Okay, the
Counselor.
minority rule says that even a completely innocent victim of a deadly attack is under a duty to take advantage of an available and safe means of retreat. So when you looked up and saw Mr. Mann quickly, it says that you did three things. It said you looked down and felt helpless about your wrist, correct?
Yes.
And that you also remembered that Mr. Mann had said something to you earlier.
Yes.
And you also had to look around and find the piece of wood, correct?
Yes.
So you had enough time to do three things, but you didn't have enough time to just see Mr. Mann coming and run.
No.
No? You do have good eyesight, correct?
Yes.
And you supposedly saw Mr. Mann with a knife.
Yes.
You can tell the difference between a knife and a wallet, can't you?
Yes.
Yes. Did you see this knife?
It's a yes or no question, and
Did you see something that looked like this?
yes.
Did you see something that looked like this wallet?
No.
No? But there wasn't a knife, was there, Mr. Stevens? There wasn't, no one ever found a knife.
No personal knowledge. No personal knowledge.
Okay, are you objecting to this?
Objection, no personal knowledge.
Sustained. Jury disregard that question. Counselor, continue with another question.
But if, even if you didn't have a knife or, but you didn't care if you had a knife or not, you just wanted to get back at Mr.
Objection,
Stevens.
speculation.
Sustained. Jury disregard the question.
Okay, Mr. Stevens, you picked up the piece of wood and struck Mr. Mann on the face, correct?
Objection, leading the witness.
Overruled. Continue with your question, Counselor.
And when you hit him, you probably heard a really loud thud as the wood hit
Objection,
his face. didn't you?
speculation.
Can I have two counselors from, or counselor from each side? Okay.
Now, one thing about objection, you need to object to try to make sure evidence doesn't get in. It shouldn't be. But also, there's
Okay, we're objecting on one question only,
Jury can
right?
get
Okay,
upset.
and you need to stop really and get, because I'm finding
So they have
myself
to
not
really
knowing
be
which question
a
I'm
little bit careful.
bringing out. So you guys are objecting to the question of the speculation. Okay, what was the question?
When you hit Mr. Mann, you heard a really loud thud when you hit him.
There's nothing in the facts that says
They
it was
know
a
what they
thud.
wanted to.
There's nothing in the facts that says it was a thud.
Regarding the question of Mr. Brad Stevens hearing a thud when he hit Mr. Martin Mann, is that the question,
Yeah.
correct? Okay, I'm gonna overrule it and you continue with that question.
When you struck Mr. Mann, you probably heard a really loud thud as you hit him, correct?
No.
No? And did Mr. Mann yell?
Yes.
Yes. May I have a 10-second recess?
Yes, you may.
When you hit Mr. Stevens, there was probably a lot of blood, wasn't there?
Objection, no personal knowledge.
Overruled. Continue with the
When you
question.
hit Mr. Stevens, there was a lot of blood, wasn't there? Yes or no?
I didn't hit Mr. Stevens.
I mean,
Order in the court.
when you hit Mr. Mann, there was a lot of blood, wasn't there?
Yeah.
Yeah. And you had a real feeling of satisfaction as he lay bleeding and unconscious at your feet, didn't you?
No.
Compound question and harassing the witness.
Sustained. Jury disregard that question. Counselor, continue with a different
Okay,
question.
After you hit Mr. Stevens, after you hit Mr. Mann, you had several options, didn't you, Mr. Stevens?
Yes.
You could have, since you claim you're using self-defense, you could have called for the paramedics to help Mr. Mann. Did you do that?
No.
Did you tell Mrs. Morgan, or Miss Morgan, to call the paramedics?
No.
Did you tell the manager, Mr. Cervantes, to call the paramedics?
No.
Did you at least get down and try to help Mr. Mann yourself?
No.
Did you at least tell the manager what had happened and that you were only using self-defense?
Yes.
After you hit him, you went directly to Mr. Cervantes and
No.
told him what happened?
No.
The last thing you could have done is run, and that's exactly what you did, isn't it, Mr. Stevens? You ran like a criminal running from the scene of a crime.
Yes.
And the only reason you stopped running is because the manager, Mr. Cervantes, caught up with you. Is that correct?
No.
No? If Mr. Cervantes hadn't caught you, you would have kept on running, wouldn't you?
Objection.
No.
Objection overruled. Continue with your
And
question.
you might still be running even today, wouldn't you, Mr.
No.
Order in the court, please. Order in the court.
Objection.
Order in the court.
Objection. Counsel is badgering the witness.
Okay, I'm going to sustain that. You can continue with another question. Jury, please disregard that question.
Your Honor.
I need order in the court so we can hear the counselor and the witness.
Your Honor, can you please ask him to scoot back again?
Counselor, would you please scoot back? You're intimidating the witness.
Mr. Stevens, I'm going to read to you the crime that you've been charged with, which is assault with a deadly weapon. The use of force or violence upon the person of another without consent committed with an object used in such a manner as to be capable of producing or likely to produce death or great bodily harm. You did hit Mr. Mann violently, didn't you?
Yes.
And you did use force. I mean, you fractured his nose.
No.
You didn't use force when you hit him?
Yes. Yes.
And he didn't ask you to hit him, did he?
No.
Order in the court.
And you did hit him with this 2x2, correct?
Yes.
And you did cause great bodily harm, didn't you? You fractured his nose.
Yes.
Calls for expert testimony.
Okay, overruled. Continue with that
You
question.
did cause great bodily harm, didn't you? You fractured his nose.
Yeah.
You basically just admitted to committing assault with a deadly weapon, Mr. Stevens.
Objection, Your Honor, harassing the witness.
Objection sustained. Jury, disregard that question. Counselor, would you please continue with a different
Didn't you
question?
just agree to everything I just said?
Objection, Your Honor, it calls for, that question is too vague.
Overruled. Continue with your question, Counselor.
Didn't you just agree to everything I just said?
Objection, Your Honor, you just...
Counselor, I overruled that objection. Continue with the question.
Didn't you just agree to everything I just said?
Yes.
And that's basically the crime that you've been charged with, correct?
Mr. Brad Stevens, you need to answer the question yes or
Oh, I
no.
thought, okay.
And that's basically, you just admitted to committing the crime, didn't you?
Yes.
So, no further questions, Your
Oh.
Honor.
Thank you, Mr. Brad Stevens. You may sit down. I need order in the court. We are now going to stop the case at this point, where we have just...
Why don't you ask prosecution if they have any more witnesses?
Okay, prosecution, would you like to bring any more witnesses up, or defense?
No, Your Honor, the defense rests.
Okay, thank you. We're going to stop this case right now, and we will continue it tomorrow at the same time, same place. And I would like to remind the jury members not to talk to anyone regarding this case, that you're not to talk to any lawyers. I need order in the court, please. We're not out yet. You need not talk to any lawyers or witnesses, or subject yourself to any information such as news, radio, and or television. And we can meet back here tomorrow. Court is adjourned.
All rise. The Superior Court of the State of California and the County of San Diego, courtroom 503 is now in session. Honorable Mary Jane Platt presiding.
You may be seated. Good morning, ladies and gentlemen of the jury, counselors, and people of the court. We're proceeding with the third day of the trial with State of California versus the defendant Brad Stevens. And we're going to continue with the closing statement, starting with the defense. Do you want me to swear in the jury again? Okay. Bailiff, would you please swear in the jury?
Jury, your eyes. Raise your right hand. Repeat after me. I solemnly swear to listen to the evidence presented in this case, to decide the guilt or innocence of the defendant. Say I will.
Defense, are you prepared to give your opening or your closing statements?
Yes, Your Honor. May I approach the bench?
Stand. Yeah.
Morning, ladies and gentlemen of the jury. On behalf of my fellow defense counsel and my client, Brad Stevens, and myself, would like to extend our gratitude to each and every one of you distinguished jurors for your patience in hearing this case, and further thanks for your continued patience during closing arguments. You've seen and heard two stories concerning the night in question during this trial. One story is full of speculations, big fabrications, even lies, and very few truth. While the other story contained lots of facts, small speculations, and pure truth. And no lies. Ladies and gentlemen of the jury, I know you have a vague idea of whether it is the prosecution telling the story of lies or the defense telling the story of pure truth. But it's been a long time. It's been a long case, and so I'll review. It's been a long case, and you might have forgotten something, so I'll review the case for you. But before I do, let's give a big hand of applause for the prosecution's star witnesses, Mr. Mann, for his performance of a liar on the witness stand. Did he do a good job? God, he was great. I mean, let's look at his testimony under, quote, oath. I mean, first of all, he assaults Mr. Stevens and injures him, but he didn't notice that. Why? Because he was too busy making threats. Oh yeah, by the way, when he was making threats, he was also being restrained on each arm by two ladies, Miss Connie Cook and Tanya Morgan, the stud. But he testified he was trying to help Mr. Mann up while being restrained. Now, let's see. Is it possible for you to be restrained like this and still help someone up? Sure you can. Your legs are free, right? You kick them, a couple kicks, yeah, they'll be up. Yeah. Only reason I can see. Then next, he admits that he was eager to spend time alone with Miss Connie Cook to, commit a second criminal act of the night, statutory rape. And that's why he was quickly going towards the door, which Mr. Stevens happened to be next to. And he admits to taking, or motioning, of taking something out of his pocket. And he admits the arcade was dimly lit. And he also admits that he can't see well in a dim lit place. But enough about him. Let's go to the honest and innocent Connie Cook. Remember how she cried after the case? She testifies in her direct and cross-examination that Mr. Mann did assault Mr. Brad Stevens first, and that she had to hold him back with all of her strength, because Mr. Mann was busy and angry making threats. She also admits that she was shocked at Mr. Mann making advancements towards Mr. Stevens when he was lying there on the ground. She also testifies that the arcade is dimly lit, as Mr. Mann. But she also testified that it is possible for Mr. Stevens to mistaken the wallet for a knife. She did testify that, if you want court records. Now, we reach the magazine Playboy reading, Mr. Richard Cervantes. Oh, man. Whose only relevant testimony was that the arcade was dimly lit and that he had caught up to Mr. Stevens, who had stopped running and willingly came back to the scene of the crime to check up on Mr. Martin Mann. Finally, we reach Dr. Agnes Chan, whose only purpose was to waste your tax money with her irrelevant testimony. She wasn't even there at the scene of the crime. But she testifies in her expert medical opinion that the nose suffered several severe blows, but the facts showed he only suffered one blow. What kind of expert testimony is this? And then she also testifies that the nose was severely broken and it was the worst she's ever seen. This comes from a doctor who works in an emergency room where people come in with broken noses from spousal abuse, other assault and batteries, car accidents, and even drive-by shootings. I find it hard to believe that this is the worst case she's ever seen. Dr. Chen, say what's left of your dignity and stop fabricating the truth, okay? Now, for our witnesses, Mr. Sidney Berg, with no reason to lie or fabricate, testified Brad Stevens' character, which is a quiet, shy, hardworking, nonviolent person. Jacqueline Bardee, also with no reason to lie and fabricate, testifies the same characteristics of Mr. Stevens. Based on her long time experience with him. Tanya Morgan, same as the first two, no reason to lie and fabricate, also testifies to Mr. Stevens' characters and also testify that he was assaulted first by Mr. Mann and that she had to restrain Mr. Mann, who also, while restraining, was also making threats at Mr. Stevens of further injuring him. And Brad Stevens also testified to the same sequence of action as Tanya Morgan has done, as Mr. Mann has done, as Connie Cook has done, that Mr. Mann assaulted Brad Stevens first, then had to be restrained, and while being restrained, was making threats. And by the testimonies of Richard Cervantes, Martin Mann, Connie Cook, Tanya Morgan, Jacqueline Bardee, and Brad Stevens, they all admit that in a dimly lit place, which the arcade was, you can't see as well, and therefore it's possible to confuse. This black wallet or this knife. Ladies and gentlemen of the jury, the defense has never denied that Brad Stevens had committed assault on Mr. Mann. We claim, though, that it was in self-defense and based all of our facts which led up to Mr. Brad Stevens hitting Mr. Mann. Facts that were backed up by our witnesses, Brad Stevens, Tanya Morgan, and the prosecution's witnesses, Martin Mann and Connie Cook. Once again, let me read you what happened. Martin Mann assaulted Mr. Brad Stevens first, made threats while being restrained, that he would hurt Mr. Stevens when next time he sees him. Then, he's eager to go home, which leads Mr. Stevens to believe that he's coming quickly towards him to attack him. And while he's coming towards Mr. Stevens, he takes something out of his pocket, which all testified could have very been easily mistaken for a knife. And under the law, the self-defense law in the state of California, it states, is the defender entitled to a reasonable mistake? The defender may act upon circumstances as they reasonably appear to be. He may assert the self-defense privilege even though he was mistaken as to the actuality of the attack or amount of force necessary to repel it. So what is the prosecution's claim that the brutality of the attack? It's legal, perfectly legal in the law. The prosecution has also claimed that the defendant was embarrassed and humiliated. Where has this been proven during the trial? Where? Nowhere. Distinguished jurors, the prosecution's job was to prove that Brad Stevens did not act in self-defense to assault Mr. Mann. In order to prove this, they must show Mr. Mann had no rights of self-defense. And did they do that? No, because their own witnesses testified to our story, our case, that he had rights to fear of a second assault by Mr. Mann. They claim that Mr. Stevens had a choice to run away or tell Mr. Cervantes, who he didn't even see. In the heat of a moment, who doesn't act on impulse? If Mr. Stevens had took time to say, oh, let me see, I could like run away, go to Mr. Cervantes, call the cops. This might not be an assault case of Mr. Stevens, but a murder case with the convicted defendant, Martin Mann. And, you know, the prosecution hasn't proven beyond a reasonable doubt that Mr. Stevens had no right to fear for his life and that he did not act in self-defense. And you know why? Because they have doubts of their own case. That's why they brought the knife in. Because they know that it was possible for Mr. Stevens to mistake the wallet for the knife. That's why they brought this in. But instead of using it for their own good, they used it for our good. Remember, the defendant has a right to a reasonable mistake of his attacker and to act on all means necessary, even picking up this stick. One swing hit Martin Mann. And that is not illegal, because the law gives him the damn right to do that. Prosecution, let me tell you what they've done today. They've wasted your tax money. They haven't done a damn thing during this whole trial, except retell you the story that we told you, and to once again tell you that the undisputed fact that Mr. Martin Mann was hit by Mr. Brad Stevens. They didn't prove he didn't do it in self-defense. Did nothing of that sort. But they want you to use your money to put an innocent man in jail and use more of your money to keep him there. And in doing that, and if you do vote Mr. Stevens guilty, you also weaken every other American citizen's basic right of self-defense when approached or fearful life, or fear for their lives when a man like Martin Mann comes angrily after them. We have proven our story. The prosecution's witness has helped us prove our stories. There's nothing left for you jurors to think about except to vote a unanimous decision of not guilty. Thank you, ladies and gentlemen of the jury.
Okay, thank you. Defense? Prosecution, are you now prepared to do your closing statements?
Yes, Your Honor.
Go ahead and come up here and do so.
Honor.
Order in the court.
Good morning, ladies and gentlemen of the jury. Let me remind you that my name is Melissa Kerrigan, and I am here, and I have been here to represent you, the people of the state of California. Now, once again, I want to extend my gratitude for you being here today. You have heard the testimonies from both sides to either prove the defendant guilty or not. We have taken the time to carefully select you from many other people because we know that you are here to be conscientious, fair, and we know that you have based your decision strictly on the facts that we have presented here. The evidence indicates, ladies and gentlemen of the jury, that on the night of June 4th at 8 p.m., the defendant, Mr. Brad Stevens, violently and without a justifiable cause, took a weapon and brutally attacked Mr. Martin Mann in the face. The facts do show that Brad Stevens used such an amount of force that he was able to render Mr. Martin Mann unconscious as well as crushed the cartilage in his nose, which required immediate medical attention. Over the course of the trial, we proved, ladies and gentlemen, that the incident between these two willing participants, Mr. Brad Stevens and Mr. Mann, was not right. It is a case of a vicious act by a coward who, prior to his attack, was embarrassed in front of his date. Now keep in mind that the burden of proof does lie on the prosecution. The testimony shows that Brad Stevens did have a motive for his actions. His motive was that he wanted to get revenge for being humiliated in front of his date. And because it was their first date, he wanted to make a good impression, just like anybody else would. Now, the defense is trying to convince you that it was self-defense. But let me illustrate to you that Mr. Stevens had a choice, did he not? He had a choice. So, I hope you listened carefully to the testimonies presented by both sides, and I hope that you are not fooled by the defense in letting them fool you into thinking that it was self-defense. I'll just remind you one more time that Mr. Stevens did have a choice. We are certain that you have seen through their devious plan by trying to present an effort to allow another violent and guilty criminal to remain unpunished for his crimes. Now, the ride is over, and it is your turn. Your turn, now that you have heard all the testimonies from both sides, to make a unanimous verdict of guilty as charged. We have met our burden of proof, and the prosecution knows that you have reached the verdict that the vicious Mr. Brad Stevens is guilty. Now, let me take you back through the testimonies that you have heard. And it is obvious that the prosecution witnesses have been consistent and lawful and highly believable. They all knew the facts and gave honest testimonies. The defense, on the other hand, acted as though they were on a roller coaster. Let's discuss each witness, and we'll start with Mr. Sidney Burke. He told you, the jury, that in order to run his business, he needed employees. And then he said that he wouldn't lie for Mr. Stevens to keep Mr. Stevens out of trouble. But don't be deceived by this, because Mr. Burke also said that he didn't know Mr. Stevens except for in his business. So, remember that Mr. Burke said that if Mr. Stevens was convicted, he would fire him? Okay? So ask yourself, why was Mr. Burke even here? It's quite obvious that the only reason he was here, and I'll tell you exactly why he was here, was because he wanted to make sure that Brad Stevens gets let off the hook so he doesn't have to hire another employee and replace Mr. Stevens. Doesn't that seem logical and unlawful? Well, Mr. Burke sure thinks so. Now, let's take a look at Jacqueline Barty. When I think back on her testimony, and I'm sure you feel the same way, all you can see is inconsistency. When she was on the stand, under oath, if you please, she first claimed to the court that she did not see Brad hit Martin Mann with a stick, but then changed everything around and said she did. How is this credible when she can't even remember that she did in fact see Mr. Stevens attack Martin Mann? Another inconsistency happens to be Tanya Morgan. Tanya claimed that Mr. Stevens was not mad when he found Martin Mann and Connie Cook when he came back from getting change. But we know that this is not true, because if it was, then such a case would have never occurred, because Mr. Stevens could not have had the chance to provoke it by pushing and elbowing Mr. Mann away from the game. Brad Stevens, the guilty defendant. He instructed Mr. Mann to get away from the machine, and when Mr. Mann did not listen, Brad continued to push his way to the game. Brad's actions caused Mr. Mann to continually lose frogs during his game, making Mr. Mann upset justifiably, which led to the slight push of Brad Stevens. Following the push, Brad Stevens fell to the floor. Brad and Tanya then left the frogger machine and pursued the fountain. Martin Mann and Connie Cook decided to leave. Not so Martin Mann could go home and commit an act of statutory rape. They wanted to leave because Tanya was upset and they wanted to enjoy their evening together. They had no idea that the other couple was still there. When Mr. Mann was close enough for Brad Stevens to swing, he swung and caught Mr. Mann in the face. Mr. Mann fell to the floor, unconscious, with a broken nose. Now, before Brad hits Martin Mann, he had time to do 3 other things. He had time to grab the stick, he had time to hit Martin Mann with the stick, and he also had time to run away. There can be no doubt that this was self-defense. It was planned. Why couldn't he have just run away when he saw Martin Mann coming? His motive was urging him to get revenge, and the reason that he did run after Martin Mann fell was because he knew that what he saw in Mr. Mann's hand was not a knife. After he hit him, he realized that it was his wallet. And he admitted to his guilt by saying that Mr. Mann did not ask to be hit. You may revert back and say, well, Brad Stevens didn't ask to be pushed, but he provoked it because he tried numerous times to push his way to the game. The attack was cruelly and premeditated. It is definitely clear to see that the cowardly defendant, Mr. Brad Stevens, is a criminal and should pay the price for his crimes. Both Brad Stevens and Martin Mann have good eyesight. That is a fact. So, if both of the boys have good eyesight, then why did Mr. Stevens say he thought he saw a knife? There was no knife. There was never a knife. We have the knife in here today to show you that there was never a knife anywhere at the scene of this crime. And Mr. Martin Mann had to run away Mr. Stevens had to run away like a guilty person because once he saw Martin Mann on the ground, he knew there was no knife. He knew he was wrong, so he had to run. Now, the defense said that our testimony was full of lies. Well, what about their witnesses? I have already illustrated to you how inconsistent their witnesses are. The actions of Mr. Martin Mann when he tried to help Mr. Stevens up were completely misunderstood by both Connie Cook and Tanya Morgan. Mr. Mann was simply trying to help Brad Stevens up because he knew that the slight push that he gave him was not enough to make him fall down to the ground and cause him to fall. He knew, so he went to help him up, yet at the same time, he was being restrained because his actions were misunderstood. The defense said many things that weren't true. What does statutory rape have to do with this case? Nothing. Nothing at all. And each witness, our witness cries, she was simply nervous. What else are you to expect? Mr. Richard Cervantes was not reading Playboy. He was reading a video arcade magazine. And last, Mr. Stevens did not come back willingly. Mr. Stevens came back because he had nowhere else to go. He looked around, he didn't know which way to go, so this gave time for the video arcade manager, Mr. Cervantes, to catch up with him and bring him back. Also, Mr. Stevens did nothing of the sort to call an ambulance, to make sure that Mr. Mann was okay. All he did was run because he knew he was guilty. All of the prosecution witnesses have testified along the same lines, and it is evident that self-defense is not acting on impulse. They are two completely different things. So now that you have heard the testimonies, ladies and gentlemen, I once again want to say thank you for being here, and I know that your unanimous verdict will be rendered guilty. Thank you.
We're in the court. Thank you. Thank you, prosecution. Now that you've heard from the prosecution and the defense attorneys and the witnesses, it is now time for you to make your decision on the verdicts. Based on the evidence and the testimonies given by both sides, remember to please not let your emotions interfere with this decision you're about to make. Base it on fact only. Bailiff, could you please escort the jury members into the deliberation room?
Sure. Into the library, annex, that's the bar room. We gotta hurry.
Okay, this is going to take a while. If you want to stay here, that's fine. If you want to go back to your room, what we can do is send somebody to tell you.
Excuse me, counsel, I need your attention here.
Sorry.
This is what we've been waiting for, isn't it? Okay, thank you, ladies and gentlemen of the jury. Have you, would you please rise, jury foreman? Have you reached a verdict?
Yes, we have, Your Honor.
Can you read that verdict to us, please?
We have found the defendant, Martin Mann, guilty.
Yes!
We'd like to poll the jury, Your Honor.
You'd like to what?
Poll the jury.
Okay, would you please stand up one by one and tell your, what your verdict was yourself?
Guilty.
What? Not guilty.
You said not guilty.
That's not a hung jury. That's not a hung jury.
That's one. That's
Wait.
one.
That's one. We still got 12 hung juries.
No, it has to be unanimous decision.
Yes.
Yes.
Excuse me, order in the court, please.
Let's continue.
Guilty. Not guilty.
Not guilty.
Okay, excuse me. This is not a football game.
I asked them if you guys not to
Jesus.
come back. I'm sorry, Jackson.
Well,
okay.
they said they in the decision, so, yeah.
Well, send them back.
Did you say unanimous? Did you tell them unanimous?
Did you say unanimous?
Yes, you did.
We've reached a verdict.
She said they reached a verdict and they, yeah.
This is a hung jury. Yep. You guys need to come up with 12 or
I mean,
none.
you only debated for a few minutes. I give it at least 15 or 20 minutes. I think you're gonna have to go back.
Gotta be unanimous.
Take them back.
Everybody has.
Jury members, please Jack, he's a man. He can't do it. No one. Jack's back.
You guys have to take your hats off.
Jack's back. Yeah.
How embarrassing.
Order in the court. Oh. Would you please rise, jury foreman? Have you reached a verdict?
Yes, we have. We find the defendant, Brad Stevens, not guilty.
Hold it out. Wait a minute.
Not guilty.
Wait, hold on. My
It's
God.
on the jury. It doesn't mean it's not guilty. Do you understand that?
I know. Well, it's
Okay,
not
would you
jury
please
anymore.
stand up one by one and tell your verdict to the court? Order in the court! Would you please stand up one at a time and read your verdict to the court?
Not guilty.
Not guilty. Not guilty.
Not guilty.
Not guilty.
Not guilty.
Not guilty.
Not guilty. Not guilty.
Not guilty.
Not guilty.
Oh!